Hello, everyone, and welcome back to It's All About Tenders. It's Monday. In today's episode, we are going to review the legal and risk factors involved with tenders. This is episode 6. Let's have a recap. You will find all this episode in my previous videos, and you can see all these episodes in my channel. Further, you can connect with me on LinkedIn, follow my group It's All About Tenders, or you can mail me your inquiries, queries, comments, appreciation on It's All About Tenders at gmail.com. Further, I also offer businesses a flexible, cost effective solution for managing tenders and business development processes. Have a look at some insights. Every tender should be routed through a legal review first to understand its gravity in case of project delays, unavoidable circumstances, etc. The legal and risk review is a crucial process for several reasons, and it helps protect both the bidder and the buyer from potential issues that could arise during the contract life cycle. Conducting a legal and risk review before submitting the tender is essential to protect the bidder from legal pitfalls, financial losses, and operational costs. It ensures that the bid is legally compliant and also that the risks associated with the project are properly understood and managed. This also increase our chances of winning. So when we do a costing and we do a legal review and a risk analysis, then we add a risk cost, example X percentage, or a contingency cost, for example dash percentage, so that all the risk factors involving the delays or penalty clauses or any other unavoidable circumstances are cleared in the financial bid and we are covered to avoid any losses. So this is a tender process. This is an overall tender submission process. I had covered the detailed explanation of each one of the points in episode 3. You may go to episode 3 and review it again. So now tell me, why is legal and risk review so important? Let me tell you then. This is important as it may lead to compliance and legal issues like, contract terms understanding. Tender conditions often include detailed contract terms and conditions. A legal review ensures that the bidder understands these and the obligations involved, the liabilities, the penalties, and the performance expectation of the client. Second is to avoid any legal dispute. Properly reviewing the documents help mitigate the risk in future disputes with the buyer, like arbitration or termination of contract. Third is identifying and managing risk like financial, contractual, liability, and indemnity. Like the financial risk associated, like it can be anything like penalties that involve a delay in work or delay in submission of invoices or the payment terms. So if you submit an invoice for a 30-day payment term and they have not paid you for like 120 days or 90 days, then you have to analyze all the risk associated before submitting your tender and the prices. Than the contractual terms, like what are the performance bonds, any change order, any significant risk it can process. Like if they say they will give you a order for 100 samples, but then they reduce it to 50 samples and they give it 50 samples to someone else, it's also called as a part order. So you have to review these terms. The third is liability and indemnity. Many documents include clauses related to liability, which could expose the bidder to significant financial losses if not carefully considered. Some other clauses are penalty or liquidated damages. Like I said, if you do not submit or complete the project on time, they can include penalty clauses. Normally in India, earlier it was 0.5% per week to 5% of whatever delay you do. The maximum cap was 5%. Now they have changed it to 0.1 percent per week to maximum of 10%. So you have to review these clauses in case of non-performance or any breaches or any delays. The second is dispute resolution. Like the contract may include clauses specifying how dispute will be handled. Example, arbitration or a litigation. A legal review ensures the supplier understand this mechanism and their implication. Like arbitration, as in when there is a dispute between a buyer and a client, so who will be the third person to resolve this dispute? Generally the client proposes arbitration panel according to his convenience, so you have to review whether you are comfortable with those clauses. Then it's termination, understanding the termination clauses, like when the contract can be terminated on what grounds. Normally these clauses are on mutual decision. Like if there is a circumstances that you need to terminate the contract for any reason, but the decision has to be mutual, so you have to review this clause. It cannot be that it can be only when the client says it can be terminated it will be terminated. No, it has to be a mutual decision. Then it's risk allocation. In many projects the contract allocates specific risk like any delays or unforeseen condition to either the buyer or supplier. Understanding who bears which risk helps the bidder decide whether the project is worth pursuing or if they need to mitigate those risks. Like some clauses that are important to be reviewed, there may be other location specific clauses. Like in India, we say time is of the essence. Like in the tender documents from the government, if you review it, they generally say time is of the essence. But however, in the United States, some companies never use term essence. They will ask to change it to time is of utmost importance. This is due to the region specific law. However, you need to consider clauses that are specific to your region. Some other clauses for review are limitation of liability. This clause aims to manage the risk associated with business transaction and can cap the amount of liability for damages, losses, or claims. This refers to a contractual provision that limits the amount of compensation one party must pay to another if something goes wrong during the execution of the contract. Then it's indemnity. It's a contractual obligation where one party, the indemnifier, agrees to compensate or reimburse another party for any losses, damages, or liabilities incurred during the performance of a contract or as a result of specific action or events. Then it's intellectual property. This rights allows creators or owners of IP. IP is something you create, you invent, and it is your own thinking. Some owners of IP to protect their inventions, works, or symbols from unauthorized use, providing them with exclusive rights over their creations for a certain period of time. Example, patents or copyright, trademarks, industrial design, etc. So the client may give you a layout. If in case suppose you are working with a refinery, the client will give you the general arrangements, the PNIDs and everything, but it is their own intellectual property. So they will restrict you to use it with any other project of yours. Then it's performance bonds. Make sure you understand the process for claiming on the bond if other party defaults. You generally have to submit a performance bond on the start of the contract. This is to ensure that if anything goes wrong, the client has some kind of money to hold you back. So now it's again time to scratch your brains. Come on, tell me. Have you ever reviewed the legal process for your tenders before submission? Has this ever occurred? What these clauses are to you? Because generally, uh, a person who does tenders just for documentation will not review such legal terms and conditions. Let me know in the comments if you have done this. So now, see you next week. Let me know in the comment section what episode should I cover next. I will be back next Monday with some more insights on tenders. Till then, I wish you happy bidding. So now it's time to like, share, comment, and subscribe. Pass it to your friends, to your industry colleagues, whom you think this might be helpful to. Unlock the secrets of winning bids and mastering the tendering process. Subscribe to my channel. See you next week. Bye bye.